Hi, I'm Lucia Zheng, a master's student in computer science at Stanford University. My co-authors are a team of interdisciplinary researchers at Stanford. Neil Guha and Peter Henderson are JD PhD students in computer science. Brandon Anderson is a data scientist, and Daniel Ho is a professor of law and political science at Stanford University. Today, I'll be presenting on our paper, When Does Pre-Training Help? Assessing Self-Supervised Learning for the Law. In this work, we aim to establish a set of NLP benchmark tasks for the legal domain and explore the conditions for which domain-specific pre-training may be worthwhile. It has been said that NLP has hit its ImageNet moment with the rise of large language models like Burp. However, curiously, existing work has reported marginal gains for pre-training large language models on law, particularly compared to the much more significant gains achieved by domain-specific pre-training in other fields, such as biomedicine and computer science. As an example, consider the core NLP task of text classification. The Chalkaitis work, one of the most comprehensive existing evaluations of pre-trained language model performance on legal NLP tasks, finds that the macro F1 gain of BERT pre-trained on law over base BERT is only 2.5, and the gain is even smaller for other tasks like named entity recognition. In contrast, the authors of the CyBERT paper showed that a BERT model pre-trained on scientific text with a custom scientific vocabulary achieves a 7.07 gain in macro F1 on a text classification task. It's worth noting that some of the large differences reported in related work like BioBERT compare BERT pre-trained at 1 million iterations and a domain-specific pre-trained model on top of BERT at 2 million iterations. And therefore, the result may be confounded by this. In light of work by the authors of Roberta, which suggests that BERT was significantly undertrained and can achieve higher performance by simply pre-training the model longer. We'll discuss how we address this issue more in our evaluation. So this all leads to the question, why have such large gains from domain-specific pre-training not been observed in law? We hypothesize that existing benchmark legal NLP tasks are not adequately difficult enough to satisfy the conditions under which significant gains from domain-specific pre-training can be observed. This may be due to the expense of hiring lawyers with legal knowledge to manually label datasets for difficult legal tasks. As a result, many private companies are unlikely to make investments in labeling unless it is for solvable tasks. So existing legal NLP datasets are not only small or proprietary, but also tend to reflect lower difficulty tasks that have been solved by methods often predating the rise of self-supervised learning and models like BERT. Armed with this hypothesis, we set about trying to construct a new large labeled dataset for more difficult legal NLP tasks. As mentioned, this is often quite expensive due to human annotation costs. So we ask ourselves, instead of relying on expert annotation, can we extract signals from case law language in a systemic way to create a task? It turns out that the answer is yes, and this is because of one of the unique aspects of case law language, that it is stylistically governed by the Blue Book rules of legal citation, which set a standard for how legal citations appear in case law. This brings us to our key idea. We could create a multiple choice question answering task by leveraging these standardized rules to extract holding statements in case law. Holdings express governing legal rules when law is applied to a particular set of facts. They are precedential, which means they are what litigants rely on for subsequent cases. In case law, holdings follow legal citations and frequently begin with the keyword holding in parentheticals, as this format is strongly recommended by Blue Book. Using this idea, we created a new benchmark dataset, CaseHOLD. The next slide shows one example from the CaseHOLD dataset. On the left in gray is a citation and its citing context. We replace the location of the holding statement in the citing text with a holding token in brackets. On the right are the 5 multiple choice options for the citing text. The green boxes are incorrect holding statements matched with the citing text prompt, and the green box contains the correct holding statement that corresponds to the citation in the case law. This dataset has around 50,000 examples, comparable in size to other general domain NLP tasks, such as SQUAD and SWAG. To construct the CaseHOLD dataset, we extract all citing context, citations, and holding statements from a holdout set of the Harvard Law Corpus, which is around 10% of the total corpus. We use the other 90% of the corpus for pre-training models, which we'll discuss in more detail in a few slides. Each example in the dataset consists of a prompt formed from the citing text and citation, one correct answer, which is the true corresponding holding statement found in the original text, and 4 semantically similar but incorrect answers, which are other holding statements sampled from the pool of all extracted holding statements. To match a prompt with 4 incorrect answers, we calculate the TF-IDF similarity between the correct holding statement and the other holding statements and match the prompt with the other holding statements with high similarity. We also set an upper threshold for similarity to prevent the matching of holding statements that parrot or paraphrase the true holding statement, which would make the task impossible. We also evaluate our model on 2 other benchmark datasets. The first is the overruling dataset, which simulates a binary classification task to determine whether a statement is overruling or not. This dataset is fairly small, consisting of 2,400 examples, and was created by CaseText, a company that collaborated with our team to release the dataset publicly. The second is the terms of service dataset, which also simulates a binary classification task to determine whether a consumer contract term is potentially unfair or not. This dataset was manually labeled by legal experts and contains around 9,400 examples. It was created by the authors of the Claudette paper cited on this slide. Next, we'll talk about the methods used to evaluate these legal benchmark tasks. To begin, we'll introduce the central Burp transfer learning paradigm, which we use to train our domain-specific models for law. This learning process consists of 2 steps. One is unsupervised training of large amounts of unlabeled text. In the case of base Burp in Devlin et al., the original paper, this is a general domain books corpus and Wikipedia. But as we'll see, this can be domain-specific text as well. BERT is pre-trained on this unlabeled text using 2 training objectives, masked language modeling and next sentence prediction. For the MLM objective, BERT masks random tokens in the input text and predicts the masked token. For the NSP objective, BERT predicts whether in a pair of sentences, the second sentence is the subsequent sentence of the first sentence in the original text. The second step is supervised fine-tuning on a specific downstream task with a labeled dataset. Using CaseHOLD as an example, we feed BERT citing text prompts as input and train BERT to predict the correct holding statement from the 5 answer choices. We trained several models using this framework. For our baseline models, we trained a 1-layer bidirectional LSTM initialized with 300-dimensional word-to-vec embeddings. For our baseline BERT model, we used the base BERT uncased model with 110 million parameters from the original BERT paper by Devlin et al. We also train a BERT double model initialized with base BERT parameters and pre-trained for an additional 1 million steps on the general domain Wikipedia corpus used to train base BERT. BERT double provides us with a model that is pre-trained for 2 million total steps for direct comparison against our legal domain-specific BERT models, which are also pre-trained for that many steps, addressing the confounding issue discussed earlier. Legal BERT is initialized with base BERT parameters and pre-trained for an additional 1 million steps on the case law corpus, the 90% of the Harvard law corpus introduced earlier. But it uses the same general domain vocabulary as base BERT. Custom legal BERT is pre-trained from scratch for 2 million steps on the case law corpus with a custom legal domain-specific vocabulary constructed using sentence piece on a subset of sentences from the case law corpus. With some initial exploration of model behavior, we can see the significant benefit of a domain-specific pre-training corpus and vocabulary for legal domain-specific reasoning. Let's take a look at a couple of examples. Here's a quote by Justice Marshall from Marbury v. Madison. "The very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury." We can transform this quote for masked language modeling by masking out the last word, injury, and feeding this input to our BERT model. We would like the BERT model to correctly predict that the masked word is injury. We observe that base BERT and BERT double do not predict the correct completion within the top 5 completions with highest likelihood. I think base BERT predicts action and BERT double predicts emergency. But legal BERT predicts the correct completion, injury, correctly. This demonstrates that domain-specific pre-training on legal text significantly improves model accuracy for tasks for which the pre-training text provides relevant knowledge, in our case, case law. Custom legal Burp predicts correctly as well, though this is not pictured in the slides. As another example, take the definition of the word affidavit from WEX, the Cornell Law School Legal Information Institute Legal Dictionary and Encyclopedia. Here, we transform the input by masking the defined word affidavit and have Burp predict this masked word. We observe that our Burp double and legal Burp models predict that the most likely word is oath, which is similar in meaning, but not as technically precise as affidavit. Custom legal Burp, on the other hand, predicts the correct word affidavit and attributes high likelihood to this prediction. We see about 80%. Affidavit is in the legal domain specific vocabulary for custom legal Burp, but not in the general domain vocabulary of Burp double and legal Burp. This suggests that the custom vocabulary contributes to additional gains beyond those from domain-specific pre-training only, especially for tasks that contain highly domain-specific terminology. We zoom out a little now to briefly discuss the details of unsupervised pre-training and supervised fine-tuning procedures we used for evaluation, and then we will present the results of the base setup and some variants. We use the pre-training procedure detailed in Devlin et al. With a few adaptations for improved performance on legal texts. One adaptation we implemented was a custom sentence segmenter that uses regular expressions based on Blue Book rules to keep legal citations together for next sentence prediction pre-training. This change was important because traditional segmenters use period characters as sentence delimiters, but there are many non-sentence delimiting periods in case law. We also used whole word masking for the masked language modeling pre-training objective. This change masks whole words rather than subtokens, forcing BERT to predict entire domain-specific terms, which are often not present in the general domain vocabulary and therefore frequently tokenized into subtokens. For fine-tuning, we use the input transformations presented in Radford et al., which allow us to train on different downstream tasks while making limited adjustments to the model architectures. Here, the green model box represents the section of the pipeline where we can slot in any of our previously described pre-trained BERT models. We'll go through the multiple choice question answering pipeline in a little more detail here, but the classification pipeline is similar. Using CaseHOLD as an example, we transform a particular example from the dataset so that the prompt is concatenated to each answer choice separately and separated by a start, delimiting, and end token. We feed each independently to the pre-trained BERT model we would like to evaluate, and this output goes through a classification head composed of a linear layer and softmax to produce a prediction of which answer choice is correct. The text below the diagram shows how this would be done for the original CaseHOLD example presented earlier. The following base setup results use this pre-training and fine-tuning procedure to evaluate the 3 benchmark tasks with tenfold cross-validation. We report average macro F1 as our performance metric. We observe that the baseline model performance for overruling is high. This is likely because the overruling task is comparatively easy. The task reduces to identifying the presence of keywords like overruled and disapproved in many cases, as these keywords commonly appear in overruling sentences. The baseline performance on terms of service and CaseHOLD is lower, which tells us that these tasks are more difficult and cannot easily be solved with a BILE-STM or base BERT. We see that BERT double and legal BERT achieve marginal gains over base BERT for overruling, which substantiates our earlier hypothesis that existing legal NLP tasks may not be sufficiently difficult to observe significant gains from pre-training language models on law. We see that BERT double achieves much higher F1 on terms of service compared to base BERT, but that legal BERT is not necessarily more performant for this task. This is likely because though terms of service is a more difficult task than overruling, the task language is extracted from consumer contracts, which contains more common language and less language similar to case law. In contrast, there is a 5.7 gain in F1 between BERT double and legal BERT, which suggests that the CaseHOLD task is both adequately difficult and domain-specific enough to satisfy the conditions for which more substantial gains from domain-specific pre-training are observed. Lastly, we see that custom legal BERT achieves the highest performance on all 3 benchmarks. The F1 scores are bolded in the table. In particular, we see additional gains beyond just domain-specific pre-training from a custom domain-specific vocabulary, as reported in other domains outside of law. We also attempted to define a more quantitative measure of domain specificity, which we call DS score. It is computed by taking the average difference in pre-train loss between legal BERT and BERT double over the dataset evaluated on the downstream task of interest. If a DS score is positive, this implies that legal BERT with legal domain-specific pre-training is able to reason more accurately about the task compared to BERT with general domain pre-training before any fine-tuning. These DS scores are reported in blue here. We see that the rank order of the DS scores matches our qualitative understanding of the domain specificity of the three tasks, with terms of service being the least domain specific and having the lowest DS score, and CaseHOLD being the most domain specific and having the highest DS score. We also evaluate the model on a few task variants. We discussed one of them here, and the rest are included in the paper. For the train volume variant, we vary the size of the CaseHOLD training set. This plot shows that legal BERT dramatically outperforms BERT double in precisely the setting that is relevant to law, where there is limited labeled training data. In conclusion, we present a new legal NLP dataset, CaseHOLD. This dataset illustrates the advantages of leveraging domain-specific knowledge, the standardized Blue Book format for holding statements in case law, to construct legal NLP datasets. Using CaseHOLD, we show gains from pre-training language models on law comparable to the largest gains reported by CyBERT and BioBERT. We hope this contribution drives excitement and interest in solving more difficult legal NLP tasks. Additionally, we outline two conditions that help identify where domain-specific pre-training may be worthwhile: task difficulty and domain specificity, and offer some ideas such as DS score about how to quantify these qualities of a task. This may guide practitioners in deciding when resource-intensive pre-training is necessary in the future. We close by sharing some resources. The legal benchmark datasets and the code for fine-tuning to replicate reported results are available at this GitHub link. We also invite you to download and explore our pre-trained language models for law on the Hugging Face model repository. You can explore model behavior using the Marbury v. Madison and the affidavit example from the slides, or any other descriptive examples of your choosing in the browser on the Hugging Face model pages. Thank you for listening. Neil and I are happy to take any questions, and our contact information is also on this slide.
Thank you, Ms. Lucia. And we have a question. In the section of related work in your paper, you have mentioned the possibility of selection of bias in available legal and NLP datasets, and this becoming one of the risks in the rise of self-supervised learning. What could be a solution of the control of the bias in the usage of self-supervised learning, and which are the risks we are facing with the non-usage of those solutions?
Yeah, so I think the question maybe is referring a little bit to the bias towards, let's see. Yeah, the bias of like towards simpler NLP data sets like being existing in the public, and the reason for that being that it is expensive to actually annotate legal NLP tasks specifically, because you have to pay lawyers with very expert like legal knowledge. And so one thing we sort of suggest in this paper that might help alleviate that issue with the cost is trying to extract signals based off the specific rules of like case law, or maybe based off any other formats of legal texts that are standardized, in order to do this in an automated fashion. And in that way, we can make large data sets much more cheaply for maybe tasks that are also more difficult, like something like multi-class classification or multi-label classification. So that can help. I think maybe another answer to that is more collaboration between these like companies and outside independent researchers, which may encourage like work towards that.
Now we can move on to the question. But before that, would you like to make any additional comments to the previous recorded presentation, Mr. Guha?
No, I'd love to hear the questions that folks have.
Okay, let's go. The first question is, due to their financial costs, are pre-trained models only recommended for difficult and complex tasks in the legal domain?
Yeah, that's a fantastic question. I think it's important to distinguish between, I'm assuming the question's asking whether we're recommending pre-trained legal models over general purpose legal models or general purpose language models like Burp with regards to customized corpora in the legal domain. And I think that's a difficult question to answer without more facts, but I think there are a variety of considerations that might inform such a decision. So the complexity of the task is definitely a consideration. Pre-trained models, and you'd think that the reasoning patterns that are present in a corpus are more likely to be important the more complex the task is. And I think that's what our work shows, especially with the performance improvements on CaseHOLD. But also other considerations include the alignment between the pre-training corpus and the data set for the task that you care about. The closer those two data sets are aligned, the more likely you're going to see a benefit from pre-training on a customized corpus. And finally is a question about the amount of data you have for the fine-tuning or end goal task. If you have less data, that suggests, and our results also indicate this, that you're probably going to want to pre-train on a you're more likely to want to pre-train on a customized legal corpora. If you have a lot more data, then it seems like you can get away with using an existing model that's been pre-trained on a more general corpus.
Great. We have another question from Thorne McCarthy. He said, your best result were from custom legal Burp. What was the training time and training cost for this model? Are you using GPUs or TPUs?
Yeah, so we trained it for 2 million steps on Google Colab TPUs, which I think took a couple of days, if I recall correctly. Because we were using Google Colab TPUs, and at the time, Google was freely giving away TPU compute. We didn't actually have to pay for it, but I'm sure I could pull up an estimate for you offline to find what the actual cost would have been. But yeah, we were really lucky that we were able to leverage this resource, and it was fantastic. I'm sorry, Leonardo, I think you're muted.
Oh, great, thank you. We have another one from Sabine Werner. Do you think one can profile the training corpora to support the claims about legal Burp, such as the important keywords are probably more frequent in the legal corpora?
I think I misheard the first part of that question. I'm so sorry, could you repeat it?
The first part is, do you think one can profile the training corpora to support the claims about legal Burps?
Yeah, and we did, I don't think we wrote about this in the paper, but we did look at relative word frequencies compared to samples of the legal corpora from case opinions, the more general corpora used to train what we call vanilla Burp, and we found that on sort of notable, for notable terms, there were significant discrepancies. And I think the examples presented earlier in the presentation in the slide with regard to affidavits show how this can manifest in a difference in performance.
Okay, great. And we have a final question. At the end of your paper, you say that code, deciding whether you want to pre-train yourself can therefore have significant ethical, social, and environmental implications, unquote. Which are the main ethical, social, and environmental implications of pre-training models? Can we mitigate them?
Yeah, that's a fantastic question. And I think a topic that's really at the forefront of mind for a lot of researchers in this field. In our paper, I think we have references to several papers that do a much more thorough job of discussing this in all its nuance and details. So off the top of my head, the stochastic parrots paper, and there's been a lot of work on trying to catalog the environmental impact. Just sort of like a brief overview maybe is that I think pre-training is very, very computationally expensive. And as a result, there's been a lot of fantastic work cataloging the extremely large carbon footprint it has, particularly when you consider how in a full machine learning process, you're not necessarily just pre-training one model, you're doing some form of hyperparameter tuning, you're running multiple tests. And so this can grow in cost and have a significant environmental impact. And I think the other consideration relating more to the ethical and social issues that arise are that these models are extremely large and unfortunately have a tendency to memorize text and regurgitate it. And with the size of training data sets we're talking about, it can be practically difficult to filter or audit the entire data. And so the likelihood that these models are able to capture harmful biases or regurgitate information that may otherwise be private or may be hateful in some way is not low. And I think those are considerations. And like I said, there's a lot of work that we cite to in the paper that does a much better job of explaining this in all its detail. And so I'd encourage everyone to go read those papers. And yeah.
Okay, great. And we have a few minutes left. So would you like to make any final consideration, Mr. Goa?
No, I don't think so. I'd just like to echo what was said earlier about thank you so much for organizing this. We can't possibly imagine how much work and how difficult it is to put together a venture like this over Zoom across multiple time zones on these online platforms. But it's been an extraordinary experience, and we're really grateful to have the opportunity to engage with the community and that the organizers put the time and effort into this. So I just wanted to say thank you, and thank you to everyone who listened to our talk.
Okay, Mr. Goha, we just received another question, and I'd like to ask you from Jack Conrad. Could you speak to future work? What could you cite practical legal applications that would be immediately acknowledged by legal practitioners as difficult and valuable use of this training?
Yeah, so if I understand correctly, the question is asking about what are potential future work along this vein, and then what are interesting tasks we think that stretch complexity. Those are two things we're thinking a lot about. I think in terms of potential future work, one of the things we're really interested in is understanding where the divergences in performance are coming from between the custom legal Burp model and the baseline Burp model. Are there specific reasons we can identify why legal Burp is performing better? And if we can identify those reasons, can we figure out how to use them to improve performance even further? I think with regards to tasks, one of the things we really liked about the CaseHOLD Dataset is the extent to which we can leverage structure already existing in legal text through holding statements, because I think that, as Lucia said, the problem with legal benchmarks is it's very, very difficult to get human labels. And so we're looking at that. There are potentially interesting things we could do around citation signals. I know there's a lot of work happening around contracts. The Quad CUAD dataset recently came out, and so that's really exciting. But I think in general, this is a really exciting space, and there's lots unfolding, and we're really looking forward to seeing where it goes.